The Akwa Ibom state government has dismissed the renewed controversy surrounding its ownership of 76 offshore oil wells, maintaining that the Supreme Court decision on the issue is final. In July 2012, the Supreme Court sealed Akwa Ibom's ownership of the oil wells, dismissing the Cross River State government's claims to them. However, recent reports attributed to the Cross River State government suggested that the issue of the ownership of the oil wells will be reviewed, and a political settlement was in the offing. In a swift reaction, the government of Akwa Ibom State stated that the decision made by the Apex Court could not be appealed or deliberated further. The State Commissioner for Information, Aniekan Umana, urged the public to disregard any circulating claims or rumors, emphasizing that the July 2012 Supreme Court ruling remains final and binding. Joining us on this show to discuss fresh moves by the Cross River State government to reclaim 76 crude oil wells ceded to neighboring Akwa Ibom State, Honorable John Lebo, a lawyer and former Speaker, Cross River State House of Assembly. He will also address the news circulating that Cameroon is allegedly attempting to take over highlands beyond the Akwa Efe River in Efatumbo local government area of Akwa Ibom State. This area is rich in oil and gas, with estimates suggesting there are around 2,560 oil wells in the region. And the Nigerian Senate is to probe the alleged illegal annexation of Nigerian territories by Cameroon. Good morning, Honorable Lebo, and thank you very much for joining us on the morning show.
Good morning, Ruben, Dr. Ruben. Thank you very much. Glad to be here.
Honorable, okay, what is it that Cross River is looking for again? There was an ICJ judgment ceding villages in Bakassi to Cameroon, and also saying that Cross River State was no longer a littoral state. Cross River State went to the Supreme Court of Nigeria twice. First time, second time, the Supreme Court of Nigeria held its position that the remaining oil wells were contiguous within the 200 meters isobath to Akwa Ibom. So Akwa Ibom became the owner of those oil wells. Now, to settle out of court, Akwa Ibom agreed to give Cross River State first 250 million on a monthly basis. That amount later increased to 500 million naira on a monthly basis. And now, years later, Cross River has just woken up to say, oh, we want to revisit that matter. The oil wells belong to us. It's Cross River State having a flight of fancy to overrule the ICJ, to overrule the Supreme Court of Nigeria. Former Attorney General of the Federation and Minister of Justice, Andoaka SAN, was on this program, saying that even when an attempt was made by the Nigerian government to do some kind of arrangement, political arrangement, Cross River State slept on its right in that regard. Now Cross River State is coming back after 20 years, after collecting money from Akwa Ibom over the years, to now say, we think, ICJ was wrong, Supreme Court was wrong. Can you tell us the basis for this sudden awakening?
Okay, thank you very much, Dr. Ruben. I appreciate it. Please, let's break it down. Let's start from the first issue, the judgment of the ICJ. Cameroon filed the petition at the ICJ in 1994. Nigerian government filed a preliminary objection in 1998, and then filed a counterclaim in 1999. The ICJ ruled in 2002. The judgment of the ICJ, I can make reference to particular pages of the ICJ, pages 5, pages 6, and pages 9, was very clear about the maritime boundary between Nigeria and Cameroon. In the course of this argument, please let us separate the dispute between Nigeria and Cameroon and the dispute between Akwa Ibom and Cross River. The dispute between Nigeria and Cameroon is over maritime territory. The dispute between Cross River and Akwa Ibom is over municipal territory. The instruments used for that demarcation, they are completely different. But the point I'm trying to drive at is that there is no portion of the ICJ judgment where the ICJ pronounced that Cross River State is not a littoral state. There is no portion of the judgment, over 960 pages, where the ICJ pronounced that Cross River State has lost the oil wells to Akwa Ibom because it doesn't have 25% isobat. The whole of that judgment is clear. Rather, what you find in that judgment is that the ICJ introduced the 1913 Anglo-German Treaty, which is a treaty that the British and the German government put up together that has over 140 pillars. That boundary line began from Michika in Adamawa State, goes to Lake Chad Basin, moves down to Obudu in Central and Boki, and then moves down to Cross River, and then moves down to Akwa Efa. So that boundary map is there. Now, our gross in this issue is that, first of all, as bad as the judgment of the ICJ is, the highest consequence of that judgment should be on Nigeria, not on Cross River State. Because Cross River State was not before the ICJ. It was Nigeria that was before the ICJ. Cross River State government, under Donald Duke as governor, provided all available evidence to Olu Onagorua, who was Attorney General at that time, to prosecute this matter. That was why the preliminary objection was filed. Part of the evidence we gave first is the protection treaty between the Queen Victoria of the UK and the chiefs of Calabar in 1884 and 1885, which showed that even before the Anglo-German Treaty was made, that territory of Bakassi belongs to the territory of Calabar, the old Calabar, which constitutes the present Cross River State. Yes, a few of our brothers are across the river in Cameroon, so that we gave them that treaty. We gave them several other documents, including the fact that Nigeria had carried census in that area. Elections have held in that area that people have voted. Nigeria government has carried out infrastructure development, and for a period of close to 100 years, Nigerian government has been in occupation of that area. So we provided that evidence before the Nigerian government. Unfortunately, we lost the judgment. After we lost the judgment, the crisis in this matter came in the interpretation of the National Boundary Commission to the effect that drawing a straight line from the maritime boundary has hemmed in Cross River State. The ICJ judgment did not in any way hem it Cross River State. And I refer to you, Dr. Ruben, to page 5, page 6, and page 9 of the ICJ judgment. In that judgment, the court clearly delineated the boundaries in the Maritime Sea between 4 different points. Point number 1 is Cross River. There's a difference between Cross River and Cross River State. Cross River is the river, is the Nigerian mouth to the Atlantic Ocean that collects water down into the Calabar estuary. That's the Cross River. That is by the west. And then you have Akwa Efa, which is in Akwa Ibom, so to say, which is to the north. Then you have Rio de Rey, which is also in some part of Mbo and across the other side, which is to the east. And then you have the Gulf of Guinea, which is to the south. That maritime boundary was demarcated over that area. Don't forget, Dr. Ruben, that when that matter was pending, Equatorial Guinea intervened in the matter. Sao Tome did not appear, but Equatorial Guinea intervened and said, don't demarcate this boundary in such a way that you destroy the tripartite point, the contiguous zone between Nigeria, Cameroon, Equatorial Guinea, and Sao Tome. Okay. And the ICJ judgment clearly did not touch that boundary, that area of the boundary. Okay. So the point I'm making is that Cross River State went to court only because after the judgment was given, the judgment was executory, not executed, in the sense that that judgment was subject to the demarcation and delineation of that boundary from Michika down to Cross River.
Honorable
the demarcation was not done, and the ICJ went ahead, the National Boundary Commission went ahead and constructed a map taking across River from the Atlantic Ocean.
Okay, thank you for that very detailed explanation. Now, one of the key issues that Dr. Abati pointed out is timing. Because whether we are looking at the issue of Bakassi, for example, this agitation is not new. There's been a consistent agitation in the Bakassi region. However, some administrations do not take it upon themselves, and some do take it upon themselves. So please tell me, in terms of timing, what is peculiar about this particular season? Same goes to Akwa Ibom, where the Cross River government has said that they'll pursue a political solution since the legal grounds are quite specific. But I want you to speak to that. Are you saying that with regards to the oil wells, are you also saying that the legal grounds on that are not specific to the execution that we are seeing currently? I want you to clarify that.
Okay, first, let me explain that usually in law, there's a difference between justice and peace. And also, there's a difference between a judgment that is executed and executory. A judgment that is executed is that a judgment is given, for instance, a monetary judgment, payment is made, the judgment is dead. There's nothing you can execute about it. A judgment is executory when the judgment is subject to certain actions that will be taken, including cartography, hydrological survey, mapping, and all of that. The judgment of the ICJ is executory because after the ICJ passed that judgment, they set up an implementation instrument called the Green Tree Agreement. The Green Tree Agreement provided for a joint means commission to demarcate the boundary. The fact is that as long as the boundary demarcation between Nigeria and Cameroon has not been completed, as we speak, the boundary adjustment in the Lake Chad Basin has been concluded. From Michika to Lake Chad Basin at Pillar 64 has been completed. The boundary demarcation from Pillar 64, which is the Benue boundary, through Cross River Central, which involves Ubudu. That demarcation, when they were about to conduct that exercise, the Joint Means Commission that came in with contingents from Sudan almost took away 24 communities from Ubudu local government and the Urban Liku into Cameroon. The National Assembly set up a committee to probe into that matter. In Danare, Pillar 113 and 114 could not be found. They're about to take about 10,000 to 20,000 virgin forests from Nigeria to Cameroon. In the Bakassi Axis, they still have 90 kilometers to demarcate the boundary. So what is the Nigerian government talking about? The issues about the location of the oil wells cannot be confirmed specific until you conclude the maritime demarcation of the boundary. What theory of geography would you apply to a judgment that provides for maritime boundary demarcation? You have not done the demarcation, and then you relocate the oil wells. If Nigeria lost the access to the sea by virtue of that judgment, it means that the map of Nigeria drops back to the Calabar estuary. You cannot replace Cross River State at the Atlantic Ocean and replace it with Akwa Ibom. Because the danger in doing that is to extend the Cameroon boundary of claim beyond Bakassi to Rio de Rey and to Umbo local government. And then Cameroon will come back looking at that area. To address the issue of timing you mentioned, the fact is that the judgment of the Supreme Court is usually a policy court. The judgment of the Supreme Court was given based on a report, an advisory report of the National Boundary Commission, which was faulty and hasty because National Boundary Commission abandoned the demarcation of Bakassi and went ahead to relocate oil wells. And so we, as Cross River State, we have not been sleeping over our rights. Our governor, Senator Prince Bassio, too, when he was senator, raised that issue before the Senate and warned against that. So we have been able to put some documentations together. We have not been sleeping since 2002. We have gone ahead. We got the consultancy of the Queen's Counsel, the wife of the former Prime Minister of the UK, Cherry Blay, who was an amicus curiae before the ICJ, advising that Cross River State is still a littoral state and the oil wells are within the Calabar estuary at the territorial sea. That document was presented before the former Attorney General of the Federation, Andoaka, and then he didn't act on it.
Honorable.
So but I'm with that information. Dr. Robert, just hold on. And with that information, Cross River State has not approached the federal government with the hydrological survey, with the geological survey. We have done our own demarcation up to that point, and we have shown to the National Boundary Commission and the federal government that the danger of saying that Cross River State is not a littoral state is not true. If you conclude this boundary, we are a littoral state. We have access through the Bight of Benin, through the Gulf of Benin, to the Atlantic Ocean. And then we have also shown that the oil wells, at least we have identified that 67 of the oil wells are within our territorial sea. And those are the issues that we have presented to the federal government of Nigeria.
Honorable, look, I've heard you. I mean, you came prepared. I'm glad you are very familiar with the details. But we also had Michael Andoaga, SAN, on this program last week. And he was a person that presided over the Green Tree Agreement with the Cameroonian authorities. He was Minister and Attorney General at that time. And he was saying, yes, that whatever the ICJ said had been executed. Every ruling in the ICJ judgment had been implemented. And that Cross River State is crying over split milk. Besides, the Supreme Court of Nigeria, on 2 different occasions, has already ruled on this matter. So what is Cross River trying to do? To overrule the Supreme Court of Nigeria? So, and I would like you to respond briefly to those 2 posers. And finally, the allegation that, that Cameroon is trying to take over more parts of Bakassi as far as, another river and all of that. What is the status of that realization? What's the basis for it? And what will Cross River State do about it? Because Cross River State, I don't think is in a position to overrule the Supreme Court.
Okay, let me break it down, Dr. Ruben, one after the other. First of all, on the issue of the Lennes Silk, Mike Andoaka, on the issue. First, he alleged that Cross River State waive his right. Let me state here categorically that that information is not correct. First of all, the National Boundary Commission came in 2008 for a presentation in respect of the boundary at a point where the governor of Cross River State, Senator Limoke at the time, was removed by a judgment of the Court of Appeal in 2008. The Speaker of the House of Assembly, Right Honorable Frank Ada, was acting governor at that point. The appeal he made to the Boundary Commission is that we're conducting an election to bring in the governor, give us 2 weeks, because the governor is the one who has the instrument. He had not considered the State Executive Council, the State Boundary Commission. He has not even received the report of the Bakassi judgment first. Give us 2 weeks so that we can do that presentation. They left to Akwa Ibom. The point I want to make about Andoaka in that point is that when Nigeria needed to go to court, they came to Cross River State and collected all the evidence. They were in Calabar. The Obong of Calabar, the paramount ruler of Bakassi were all involved in that whole process to go to court. Now, Cross River suggested to them that to save a portion of Bakassi, create Bakassi local government of West Bakassi, preserve those islands called Core Island, Day Spring 1 and 2, so that we do not lose our maritime territory. Abacha did that and created that local government. Those information are all available. Michael Andoaka cannot claim that Cross River abandoned their rights and that we did not do presentation. They had our documents that they used in the ICJ. What extra documents were they looking for? Beyond that point, when Senator Liye came back as governor in August, he went to the then vice president, Jonathan Goodluck, with our presentation. They rejected it and said it was late. How important, to whose interest is it for Cross River State to lose its maritime territory at the Atlantic Ocean, where you already have a seaport, you have the naval operation, you have the Calabar EPZ? That is the point on that issue. On whether Cross River State wants to overrule the Supreme Court, no. The judgment of the Supreme Court is final. But the implementation of that judgment has hit a gridlock. And unless you conclude that boundary demarcation, we will not resolve that issue. These are internal matters. It's not the ICJ judgment. The ICJ judgment did not declare us as a landlocked state. Now, with what has happened is that the judgment of the Supreme Court, Dr. Ruben, is first of all a policy court. The judgment of the Supreme Court was inspired and influenced by a wrong policy advisory decision of the National Boundary Commission. They had not concluded the hydrological survey to know the geolocation of those oil wells. They have not even concluded the boundary demarcation between Cross River and Akwa Ibom, and they went ahead and did that location. We have done our survey, we have done our report. We work with the Surveyor General of the Federation, National Boundary Commission, Revenue Mobilization, and we have presented a report on security grounds to the President. To the President. So to summarize on that point, one of the ways you can set aside the judgment of a Supreme Court is if there's a new policy or there's a new law. We expect the federal government to now send it to the National Assembly for a law to establish this perspective that National Boundary Commission change. Once that happens, the judgment of the Supreme Court will become nugatory. We don't actually need to go to the Supreme Court directly on that point.
But only the Supreme Court can reverse itself. The executive cannot dictate to the Supreme Court of Nigeria.
Yes, but no. The offshore and offshore dichotomy issue is very clear. There was a judgment of the Supreme Court. The National Assembly passed a law. I'm not saying you overrule yourself. I'm saying that the impact of that judgment will become academic. Supreme Court can amend the decision. We're not even going to that point. We're saying that we'll have to have a post-case management strategy that deals with that issue for the benefit of both parties. On the last issue you raised about what Cameroon's claim in that area, the boundary that the 1913 Anglo-German Treaty brought to us started all the way, Dr. Ruben, from Michika down to Calabar River and to Rio de Rey, which is off the coast of Mbo local government. The Cameroon claim stops at Bakassi. That means that any boundary demarcation you're doing should stop at the mouth of Akwa-Efa, between Cross River and Akwa-Efa. That was what the judgment said. National Boundary Commission drew a line, took out Cross River State and took it straight to Rio de Rey and to Akwa-Efa, which is why the Cameroon government has moved ahead to take over 16 islands in Efat Island in Mbo local government. And that is one of the Nigeria's richest points with 2,600 oil wells. I'm not making a baseless claim. You can Google and check. The former Speaker of Akwa Ibom State House of Assembly, my dear friend, Anye Kanbasi, brought a motion on the floor of the House of the National Assembly, Senate, asking for the intervention of the Nigerian government to save 2,500 oil wells. The point I'm making is that the open-ended and the error of judgment-based line drawn by the National Boundary Commission, the Nigerian government should, in a matter of urgency, call them to order and look at the Navy hydrological survey Cross River State has submitted to put this matter to bear. We don't, Akwa Iboms, they are our brothers. Of course, yes, they offered 250,000 to Senator Lebo, but the question we ask is that you are giving us 250 in respect of what? Oil wells located where? What about the day Akwa Ibom chose not to give us the money? We were ready to wait for that judgment. The dispute now is not between us and Akwa Ibom. The dispute now is between Cross River State and the era of judgment. Time, yes, time has passed, but we have spent time to put up a report. We have spent time to show. Mike Elandoaka himself agreed that some oil wells are within our territorial sea. Didn't he realize that when they went ahead and said we're not the littoral state and we do not have oil wells? They will reverse themselves. And the point we're making is that it is in the interest of Nigeria. Please, Nigeria should not encourage Cameroon to move beyond the Bakassi Cross River down to Rio de Rey, beyond Akwa-Efa, to look for territory, because that is where we're headed.
Let's talk about that, because when the issue of Bakassi resurfaces, as it does consistently, the conversation is around sovereignty, where those in Bakassi themselves are saying, we didn't ask for this. How did we end up in this arrangement? But this is what the ruling was, and this is what has been implemented. So beyond, the international courts and locally the Supreme Court, is there no chance of any type of referendum where the people can choose where they want to belong? Very briefly, sir.
Well, first of all, if I heard you clearly, you were a little bit faint. But if I heard you clearly, the point is that first of all, separate the judgment of the ICJ as a judgment between Nigeria and Cameroon, not a judgment between Cameroon and Cross River, because that is the first mistake we've made in all of this matter. That's one. The judgment of the ICJ, if implemented on the 1913 map, places the boundary between Nigeria and Cameroon on the mouth of Cross River and the Akwa-Efa. Akwa-Efa in Cross River State. Akwa-Efa is on the north of the Atlantic Ocean. Cross River State is on the east of the Atlantic Ocean. That is where he puts the boundary. That placed Cross River State in front of the Atlantic Ocean, one. The issue of whether or not Cross River State is not the littoral state is an internal decision of Nigeria, which was not necessary. All our argument is that you just have to wait. 90 kilometers of that maritime boundary has still not been demarcated. As at now, we have not been able to specify to Cameroon that your boundary stops in Bakassi. Don't move beyond Bakassi. We have left it open. National Boundary Commission went and drew a map that entered Akwa Ibom. That is why Cameroon is now looking for oil wells in Akwa Ibom. The point I'm making is that the internal issues relating to the judgment of the Supreme Court can be addressed through different ways, whereby a policy change by the federal government, by a law of the National Assembly. If that is done, there's a gazette showing the Nigerian map. The Nigerian map that was used to take away those oil wells were temporary maps. At the end of the demarcation, a proper map of Nigeria will be drawn up. Don't forget that the reason why Cameroon went to court against Nigeria, caught Nigerian nappies, that Nigeria did not reflect the 1884 treaty showing the boundary between Bakassi, ownership of Bakassi, to Nigeria in the map. That's why they went to court. We are making the same mistake.
On that
Cross River State argument is that if you conclude the demarcation exercise, you realize that we're a littoral state and the oil wells are within the Cross River estuary.
On that note, we'd like to thank you very much, Honorable Lebo, for joining us on the morning show. I admire your passion, your commitment, the loyalty to Cross River State. But this is a developing story. I'm sure there will be other sides to this story.